new IA is necessary because the old IA in that it is your lordship not. Maybe
Uploaded is. It
again.
has been uploaded.
No, I have taken the certified copy.
Then
It has to come.
list कर दो. List में आपको supplementary है sir. Supplementary आगे कौन आता है hearing?
Again. Next week.
हाँ, next week supplementary list.
Obliged muscle.
Supplementary list item number 1, fresh admission.
Pardon to mention, your worship. Worship is the RSA of year 2006. The sole appellant's guide we have filed IAs to substitute it.
Yes, sir. Yes, please.
The petitioner seeking transfer of the MC case, my lord, 41/2013, my lord, of arising out of PWDB Act, my lord, from the court of the STJM to JMFC Bhubaneswar, my lord.
All right, notice. Give a date.
25th October.
25th October.
Entry,
You have not filed any application. There is no IA. Otherwise, I would have granted stay.
sir.
Item number 2,
May I please? This is a transfer application, my lord, and all the proceedings between the parties, my lord, under that is under Annexure 1, that is the GR case instituted by the opposite party, and under Annexure 2 series, that is PWDB Act case that is instituted by OP number 2, and also a Section 9 application instituted by the present petitioner, that is also there, and divorce proceeding also, my lord, CP number 246 of 2018, that is page 36 C is getting the interim maintenance under Section 24, that is also pending at Kendrapada. All the cases between the parties are pending at Kendrapada. Now, she came up with a idea of filing a 125 petition before the family court Baleswar. And the petitioner is a government servant, my lord, and he is now posted at Pottamundi.
All right, notice, stay.
Obliged.
item number 3,
Data column,
25th October.
25th October.
Obliged.
May it please, your worship. The wife petitioner, my lord, seeks transfer of the matrimonial suit. That is the divorce petition, my lord.
Sir, let me just check up this writ appeal order.
Yes, ma'am. The earlier TRBC was also filed this wife.
How can a writ appeal lie against an order?
Maintainability was questioned and it was dismissed.
No, it has been dismissed on merit. No grounds have been made out for interference, the writ appeal is dismissed. Mr. Das? How can a order arising out of a transfer application be subject matter of a writ appeal? The writ appeal is letters patent.
Yes.
Letters patent and after amendment of the CPC.
Yes.
Surprised? Anyway,
High Court rules is.
so you had approached this court earlier
My lord.
and you have lost it.
Yes, my lord. Yes, my lord. That is admitted. My lord. I have stated in this.
So how is the subsequent application maintainable?
My lord, why I am saying your lordship would find there was an order, subsequent order. At that point of time, my lord, these orders were not in existence. A maintenance order was passed by the on a law and code below. Your lordship would find at page 65 it starts and 69 is the operative portion. That is an order passed by the law and code below under DV Act for maintenance, my lord. Your lordship would find the respondent number is number 1 is directed to pay an amount of 25,000 to the aggrieved petitioner within 10th day of each calendar month. Respondent, well, there were maintenance awarded by the court below in a DV Act case, as well as Miller Section 24 petition filed by me. So these all are subsequent orders, Miller. After that order was passed, Miller, all the maintenance.
Now you want transfer of which case?
Miller, the matrimonial case, the divorce proceeding, Miller, that is MAT suit number 30 of 21.
All right, take notice. Notice, stay. Paper?
25th October.
25th October.
Item number 4.
My lord. For the wife, my lord, for transfer of the CP number 232/2024 pending for the Lord and Judge Family Court Puri to Law and the family court, Khordha, Banapur, my lord.
Yes, sir. Yes,
Camp code Khordha at Banapur, my lord. I am for the wife.
Camp
My
code.
husband filed destruction of a conjugal and posted to 3rd September this month. This month, my lord. 3rd September for appearance, my answer to my lord.
Camp code कौन?
City code camp.
It has to be transferred to the main court. सी तांकर कैंप पुट करियो न करियो को आप ଆପଣ କହିବେ?
ଆଜ୍ଞା
ହଁ କଣ ଆପଣ କହିବେ?
ନାଇଁ ମୋ ଘରଟା ଅବଶ୍ୟ ସେ ବାଣପୁର ତ
ଆରେ ବାଃ।
ପାଖ।
Anyway, notice stay 25th September. No, 25th October. Hey, Mr. Bera.
ଆଜ୍ଞା
25th October.
Item number 5.
May I please versus? Discuss this is Anganwadi worker migrant.
Yes,
This is a Anganwadi worker migrant.
repetition, yes.
And there is in advertisement there is main criteria that only scheduled tribe person be selected as Anganwadi worker.
Yes.
And out of 6 candidates, the present petition is the only.
आगे ठीक.
Out of 6 candidates, the petitioner is the only
Scheduled tribe candidate.
minor.
Yes. So
This is the second round application. You will receive directly to file appeal and in appeal,
where is that order?
Annexure 6 minor,
Annexure 6.
page 29.
Annexure 6 is the order of this court.
Minor.
Mm,
I have filed appeal before.
let me read the order.
Minor.
So you were granted liberty to file an appeal before the ADM.
Minor.
So you filed an appeal.
Minor.
It was rejected.
Minor.
Thereafter you filed second appeal.
No minor.
No?
It's
तब तक सर आप हाई कोर्ट को पढ़े इसमें बेटा you have been given an order referring to that guideline dated 23/8/2024 तेरा 23/8 होगा 23/3 होगा
সেটা 15/3/2023
15 টা ভুলে লেখা হয়েছে anyway there is second appeal lies to the RDC thereafter you come to this court I'll grant you that liberty.
minor.
Yeah. The petitioner was earlier before this court in WPC number 6882 of 2024, challenging her non-selection as Anganwadi worker of Bandela Pass, BANDELAPS, Anganwadi Center, which was reserved for scheduled tribe candidates. Stop. The petitioner claims to be the only scheduled tribe candidate, but was not selected. This court, by order dated 2/4/2024, granted liberty to the petitioner to prefer appeal to the collector/ADM as per clause 8 bracket small g of the guidelines dated 15/3/2024. 15/3/2023. এটা ওটা ভুল লেখা হয়েছে অর্ডারটা এটাকে রিকল করার কথা anyway the petitioner preferred an appeal which came to be rejected by order dated 29/6/2024 passed by the ADM Ragada. Challenging such order, the petitioner has again approached this court in the present writ application. Stop. This court observes that the remedy of second appeal is provided in the revised guidelines under clause 8 bracket G to the Revenue Divisional Commissioner of the concerned division. Stop. Since alternative remedy exists, the writ application is disposed of, granting liberty to the petitioner to avail the same by filing appeals within a week from today. Stop. If such appeal is preferred within the stipulated period, the same shall be considered and disposed of in accordance with law after granting opportunity of hearing to the petitioner within 2 months.
Yes, segment is
Okay.
2 weeks may be granted, 2 5. The
1 week,
RDC
1 week, 1 week, 1 week.
item number 6,
If she can come so promptly to the High Court at the drop of a hat, she must file the appeal also.
is at Barampur, the petitioner village at Raigada, Kasipur. That's it.
ରାୟଗଡ଼ା ହେଲେ ବ୍ରହ୍ମପୁର ଆରଡିସିଙ୍କ ପାଖରେ ଫାଇଲ କରିବି।
Message. It
କରିବି
will take some more.
ଆଚ୍ଛା ହଉ 2 weeks କରିଦଉ 2 weeks କରିଦଉ।
Oh, bless. Item number 6.
Here also, my lord, the prayer is almost same, but the second round litigation. Only thereafter, after your lordship granted liberty to file appeal, thereafter annexure 11 has been passed, the notification, and the selection process has been over, but that is why I am before your lordship.
No, but you can always file an appeal. No, is this under the old guidelines or the?
This is also 22,
No, when was the original order of, was this a,
23.
no, you are challenging your non-selection,
No, my lord.
then
Disengagement.
disengagement. Also you were working and thereafter you were disengaged.
Yes.
Then again, second appeal also lies. But when was the order of disengagement passed?
That is 23. Annexure 4, my lord.
Annexure 4, yes.
Lord.
No, this is the order of the
Order
circular.
passed by your lordship, my lord.
No, original order of disengagement. That was probably passed prior to coming into force of
16,
the
12,
guidelines.
22.
Sir,
16, 12, 22.
then the old guidelines will apply. Then we can take no
That is
cognizance.
why lordship has passed the order by annexure 4.
Annexure 4.
Yes, lordship. Case 25, the
25 is something else.
I'm sorry, my lord, 26
Who will
starts
find the
from
deficit?
31.
Your writ application number is 19369.
19369. Yes,
Santoshi
32.
Kumari Sethi.
Case 32, lordship.
Let me just.
Impugned order.
Who filed the full. What? On what ground? What has happened? Why were you disengaged first?
Annexure 10, my lord. The allegation is that there are some allegations from different corners that I have misbehaved some of the parents and also the officers higher ups. And I was demanding 200 rupees for this Mamta Yojana. These are the allegations. After 13, 14 years of service, my lord, I was engaged in 2009. And the allegation for the first time came in 2023, my lord. So there is no allegation prior to this, my lord. So there are some vested interest persons, my lord, they have alleged. Accordingly, process was started and this is the result.
No, what happened? How was the appeal decided against you?
Lordship,
What was the reason for rejection of your appeal? What grounds? On what grounds are your appeal?
in order the ADM has passed that on verification, it is found that when the officers went for verification and all these things, they also reported that yes, she behaved like what was earlier she was.
Then?
And the allegation found to be correct according to the ADM law.
Where is that order? Annexure 10.
Lordship.
Let us see.
Starts from 84, my lord.
An inquiry was conducted. Statements of several witnesses have been recorded. So why should this court interfere now? We're purely finding a fact.
Lordship.
Actual
Annexure
finding, why should the
3,
court?
if your lordship will look at annexure 3, my lord.
Annexure?
Case 24.
No, I'm looking at the impugned order.
Yes, lordship, I absolutely.
Looking at the impugned. In order to ensure the genuineness of the allegations leveled on so and so and other connected witnesses of the above case have been conducted by the undersigned on Ethne and their depositions have been taken. After hearing and obtaining depositions, so this is a purely
Annexure 3. my lord,
subjectively, he has been the order has been passed on his subjective satisfaction basing on the inquiry. basing on the depositions of the witnesses. So why should
Sir,
this court?
see page 20, my lord.
Page 20.
Page 20. my lord. The petitioner, the villagers have said that earlier to this, my lord, there is no allegation against it, and she was functioning, and sincerely she was discharging her duties.
No, Mr. Acharya. You were given an opportunity. You filed an appeal. The appellate authority considered the materials. If you can show something that some materials were not considered, or it is a perverse finding against the weight of the evidence on record or something like that, why should this court interfere in a certiorari proceeding?
In fact, the allegation is that she has not received the notice and intentionally.
No.
Yeah, that-
Maybe,
that-
but ultimately she was heard.
Lords,
Ultimately she has been heard. I was just going through.
lords.
Quite a lot of, attempts were made, including sending the notice through WhatsApp and
Yeah.
all that. Nevertheless, you were given an opportunity of hearing. That is what I was trying to find out. You have been given an opportunity of hearing.
After 13, 14 years of service, my lord,
Okay,
there is
yeah.
no allegation prior to
Okay.
this, and only.
Allegation
this is
proved
the-
नहीं थी और allegation नहीं रही लगी.
This is a political.
These are the charges proved.
Lordship, in fact,
No.
when the husband of the petitioner was elected as the.
No, Mr. Acharya, I am not in plan.
Committee Sabha of the block, my lord, thereafter the allegation started, my lord.
Maybe.
There is a political rivalry that I. Of course,
Kitchen
that is very difficult to prove.
irregularities in distribution of eggs, pregnant and lactating mothers also not providing HCM to preschool children regularly.
Done in
So the appellant has been
2020,
demanding
my
rupees
lord, this
200 each.
allegation has been-
Well, let us just take instructions.
Yes.
Then State Council shall take instructions in the matter. Is this matter on, what a short date call?
20th September.
20th September.
Like pray one thing, Lord, status quo on date. I am not there, but
Status quo
process has not started.
status quo रिवानी एंड कर दो जे
Function,
any selection made pursuant to advertisement dated 15/7/2024 shall abide by the result of this writ application.
great.
Item number 7. 7, may I please, your lords? And in this case, the petitioner has challenged the implement order at Annex 6, wherein the sub-collector has passed stay the selection process in certificate appeal case, my lord, under miscellaneous certificate.
Similar matter, I think we have.
This matter was adjourned earlier.
Oh,
my
this
lord,
matter.
directed
Why
to
was it
take
adjourned?
instruction.
Why was it adjourned?
My lord,
Shall take notice as regards the competence of sub-collector to stay the selection process while functioning as the appellate authority under the miscellaneous certificate rules.
Right.
Yes. Yes, sir.
Sir, that he has done, I have asked him to explain how you could do that, but he has not replied.
Then we'll vacate the order.
As your lordship, please.
We'll vacate the order simply as simple as that. Or I'll grant you one more opportunity next week,
As your lordship, please.
as requested by London State Council. This matter next week. As funny matter, na?
13th September.
13th September. Previous order be complied with positively, failing which the matter shall be disposed of on the basis of available materials on record. Now you are asking for stay of the which case?
Stay of the further proceeding of the matter appeal certificate case number 1 of 2020.
How can that be stayed by this court?
ନାଇଁ ସେଇଟା stay କଲେନି ବୋଲି ସେ ବର୍ତ୍ତମାନ ତାଙ୍କର success ହେଇଗଲାଣି. As per my instruction,
ଦେଖିବା, ବ୍ୟସ୍ତ
sub collector has
Altogether
I'll just grant him one more opportunity.
Independent.
cancelling
That
the
is an
certificate of-
independent.
Don't worry. If the order goes,
My lord,
then if the order ultimately is quashed by this court,
my lord.
then will you not get back your relief? That's all. No interim order now.
ନାଇଁ ସେଇ ଏଇଟା ତ stay ହେଇଥିଲା ଗଲା.
ସେ ଯାହା ହେଇଥିଲା ହେଇଥିଲା. Interim order to continue.
Item number 8.
May I please, your lordship? Challenging in the selection of opposite party number 5, selection and appointment of opposite party number 5. The petitioner preferred appeal. And the appellate court passed order at page 30, kindly have a glance. Second, third, last 2 paragraphs.
Yes.
It is seen from the residential certificate issued to the appellant in resident certificate case number so and so and that Shanti Murmu alias Soren belong to village Sardabandha. Similarly, as per residential certificate issued miscellaneous certificate so and so, Guni Hasna belongs to village Bado Tikayatpur. As per the information supplied by the opposite party number 3 through RTI Act, it transfers that Dubukasahi is hamlet village under the revenue village Sardabandha, whereas Bodotikayatpur is a revenue village under Raiunia PS. It is revealed from the service area list submitted by the CDPO Jaleshwar that Dubukasahi mini Anganwadi center situates within the revenue village of Sardabandha. So question arises how the selection committee selected the respondent number 3, who is the present opposite party number 5. Who belong to the village Bodotikayatpur, and to that effect no such document has been placed to substantiate the case. The CDPO Jaleshwar has mentioned in his para-wise report that respondent number 3 was an Anganwadi helper of Bodotikayatpur since 25/11/2008 and joined as Anganwadi worker 2/2/2011 in the above Anganwadi center. 2 ବର୍ଷ ମୋଟେ ସେ ତା ଦେହରେ କାମ କରିଛି. As it is held, next page, as it is held that proper inquiry about the residential status of the applicant and respondent number 3 has not been taken up prior to selection of Anganwadi worker in respect of Dubukasai mini Anganwadi center, and this case needs proper adjudication at the level of selection committee. Yesterday, your lordship said that the quasi judicial authorities have no power.
Did you examine that?
Yes. The education tribunal.
He did the same thing which I have said.
Something different.
What different, Kunal?
In this case, education tribunal remitted back the case to the director. And this honorable court held that since tribunal, the statute provides the tribunal will adjudicate the matter, it cannot be remitted back to the authorities. In this case also, statute provides that appeal is there.
There is a difference. Probably I was mistaken yesterday. I stand corrected. This is an appeal. Appellate authority inherently has the power to remand.
Yes, ma'am. And
it was a mistake on my part. It was mistake. I was mistaken. That Harjit Kaur.
Yes,
that judgment is. I have also relied upon it.
Yes. Your lordships have also judgment.
Yes.
that judgment.
But that is, you see, in that case, the tribunal was not functioning as the appellate authority, but as the original authority.
Yes.
Being the original authority, you cannot challenge.
Here, the ADM is sitting over the
as an appellate authority. That is the distinguishing feature, which I somehow failed to notice yesterday.
Yes, madam. And the order was passed. It is a poor lady.
If the lordship will come.
That the selection authority should act upon the order of the ADM. So I will direct them.
Yes.
To act upon the order of the.
It is also passed order that the committee inquire into the matter and discussed about afresh by examining the documents filed by the appellant and respondent number 3 of being heard.
6th
December ବର୍ତ୍ତମାନ ଯେ ପୁଅର ଲେଡି ତା ହଜବେଣ୍ଡ ଡେଲି ଲେବର ଏପର୍ଯ୍ୟନ୍ତ ତାକୁ ନୋଟିସ
6 December 2014
ଆଜ୍ଞା 10 ବର୍ଷ ହେଇଗଲାଣି କିଛି ନାହିଁ.
ସେ କହୁଛନ୍ତି ଯେ that no action.
No, you take instruction. It may have been disposed of. How do we know? Let him take instruction.
କିଛି ଆମକୁ ନୋଟିସ ଫୋଟିସ କିଛି ନାହିଁ.
ଆମେ ଜାଣିଦେବାନି.
Next week asu over telephone we can also take next week.
The Manati Learned Counsel of the petitioner submits that the order remitting the matter to the selection committee for fresh consideration was passed by the ADM way back on 6/12/2024. But as per his instructions, no action has been taken on such order passed by the ADM even till date.
And also no notice has been issued.
Land State Council is directed to take instructions in this matter as to what steps were taken pursuant to the aforesaid orders passed by the ADM. List this matter next week.
Next week, ma'am.
List this matter next week.
Oblige.
13th September.
Item number 9.
Pardon, my lord. On behalf of Mr. Vishwa, I pray for next week.
Next week. Next week.
20th September.
List this matter on 20th September as prayed for.
Item number 10.
10 to bola? Acha 10.
After
10 I am on Vishiman. Would the lordship kindly permit me?
History of final hearing.
କରିଦେଇ ପାରିବେ କି ମୁଁ ରେଡି ଅଛି ଯଦି ଆପଣ
ଆଜ୍ଞା?
କରିଦେଇ ପାରିବି ଯଦି କହିବେ ମୁଁ କରିଦେବି।
ଆପଣ କରିପାରିବେ ଯେ ମୁଁ ଶୁଣିପାରିଲା ସାରି ପାରିବାର କଥା ନା ଆଉ ମୁଁ ବୁଝିପାରିବିନି ଇଏ ହବନି ଶନିବାର ଦିନ ପୁଣି ତାକୁ ପୁଣି ଭିସିରେ ପାଠ
Sir, ମୁଁ ସେ I was just going to wish your lordship happy Saturday.
well happy or unhappy that we will see as the day progresses but then all right let's just matter on
My lord, only one thing.
oh,
On the last occasion, I had filed one additional affidavit,
yes
and there I had annexed one document saying that it is to be E/4.
it is to be
E/4, annexure E/4.
yes
But so far the documents with annexure B/4 to D/4,
yes
that affidavit, my lord, I could not file. So later on, my lord, I filed it on 22nd August 2024. He already e-filed. I may be permitted to
Alright.
submit it.
so this is a document only
Yeah, no, document along with the supporting affidavit.
affidavit okay. You have given copy to Mr. Rathod?
I think.
Yes,
my lord,
yes, I have received copy.
Oh.
The same thing they have
Yes,
repeated.
yes. Yes.
They have said the same thing. So
Learned
so the
State Council
document missing.
files the affidavit enclosing all the documents which was e-filed earlier.
On 22nd August, my lord.
Sure, stop. Copy has been served on the counsel for the petitioner. This is matter on 13th September.
13th September. Yes, my lord.
Yes.
yes, sir.
11 Millard.
Important ଥିଲା କି ଥିଲା? ନାଇଁ।
Lordship had directed the state council to take specific instruction on clause 1 and clause 4. Yes.
पानी देंगे वो कहते पानी पी ये पानी देंगे मागी yes कौन है जी clause 1 and clause 4
Clause
yes
one-
yes
harmonious
Anganwadi
reading of
helper.
clause 1 and clause 4.
अंगनवाड़ी हाँ
Anganwadi helper. As per the
गाइडलाइन
guideline,
4 को मिसेक पढ़िए ना
so one tere lekha hela village public Anganwadi center.
सेटा अगर हो why both have been given because if two persons belong to the same village then the person who stays within that service area will only be considered that is why both have been given
Yes, ma'am.
Voilà.
And
Now,
later on, my lord, in annexure 4, clause number
Clause 4.
4, there is no such indication with respect to that village Anganwadi center.
no but that has to be read along with
Yes.
one if one cannot be ignored
Yes, ma'am. And in other cases, my lord, our stand is very specific to that. That a person cannot be.
Achha, let us see where is the where is the guideline relating to engagement of Anganwadi helpers सेटा कोडी
Helper, my lord, that is 97.
97 को केते पेज नंबर केते
Sir, सेटा होची.
सेइतु जणा पड़ जो
Sir.
yes 97 in supersession of all legal instruction I am directed to convey the following guidelines
Yes, sir.
to be eligible for selection as helper for an Anganwadi center, the following eligibility criteria must be fulfilled. She must be a lady of the locality and acceptable to the Anganwadi worker.
Anganwadi worker.
Now, this is again open-ended.
Yes,
She must be a lady of the locality
locality.
and acceptable to the Anganwadi worker.
Yes.
So, this has to be read along with the clause 4.
Yes.
Yeah. Lady of the locality, what will it mean? Of the locality means locality in which the Anganwadi center is located.
Anganwadi center.
Yes.
Isn't it?
Yes, ma'am.
Here, what has happened, Mr. Naik?
Lord, here the Anganwadi helper belonging to other Anganwadi center of the same village has been appointed here. There are 4 Anganwadi center in the village. She belongs to.
Well, I would like you to, you see, when so it all boils down to interpretation of the word locality.
My lord, my lord,
Correct?
my lord.
So locality, there are two ways, either to make a restricted interpretation or to make a enlarged interpretation. Broad interpretation can also be made. She must be a lady of the locality and acceptable.
Yes.
To the Anganwadi worker. So the person who is, so the Anganwadi worker also has a say in the matter.
Yes.
She must also certify that yes, this person can work with me. We'll hear it on some other day. Please examine further judgments of you can find. The first of all, what is the dictionary meaning of the word locality?
Locality.
Because it has not been defined in the Act. This has to be read with clause 4 of the other guidelines.
My lord.
when it comes to selection of Anganwadi workers, it has to be locality and acceptable to the Anganwadi worker. And what touch? Did you get it, Mr. Patnaik?
Yes, ma'am. Yes, ma'am.
We will pass a judgment here, interpreting
Yes.
the,
Yes, ma'am.
but not today. I'm not reserving it today. Keep it to next week, maybe.
Yes.
The guideline of the government which has been clarified.
Because again, at the bottom, you see under clause 2 of this guideline, procedure for selection, it says the above committee should select the helper in consultation with the women groups of the village.
Okay.
This now becomes a larger area.
That's it.
As compared to the locality, it becomes a larger area. Mane Mahila Sabha ko?
My lord, may I pray, my lord, one thing more. My lord, this appeal has been disposed of. The decision has been taken by the sub-collector of Baleshwar, my lord, taking into consideration the guideline which has been issued and the clarification issued by the DSW of Baleshwar. But
He is
once your lord-
competent.
that, my lord,
He is not competent.
once your lordship is going to dispose this particular matter, my lord, considering all these aspects with respect to the scope of the consideration of the different candidates of the area and the definition of the area, my lord. May I take, my lord, 2 weeks time to get a clarification in this particular subject from the government itself? So that, my lord, I think it will be,
It will be actually, even if the government issues some clarification, till date, since no notification or clarification has been issued, then it will depends on the interpretation made by this
interpretation
court.
of the. So at least, my lord, if the government's clarification was contrary to the clarification issued by the DSW, then this matter will be interrupted. Since government is also a party, my lord,
You must read it very carefully because it says,
there are different type of.
no, eligibility,
Yes.
when it comes to eligibility, it is very clear that she must be a lady of the locality
Okay.
and acceptable to the Anganwadi worker.
Yes.
Now, when we say acceptable to the Anganwadi worker, it means Anganwadi worker of the center in question.
Yes, ma'am.
So obviously, this will refer to a person who has been working under that Anganwadi center. If we make a harmonious reading.
Yes, ma'am.
If that is the case, then obviously Mr. Naik has a case. He says that if I don't know, I'm not seeing the facts,
Yes, ma'am.
but according to him, the person who has been selected belongs to some other Anganwadi
ma'am.
center.
My lord, today one metro was there, which was Arjun, my lord. There they have stated that it is Anganwadi helper is getting promotion to the post of Anganwadi worker.
That is wrong.
Like, because of such type of sent,
I think
words which have been
no, no, this
utilized
will
in
settle-
different guidelines, my lord.
This will settle the law once and for
Yes,
all.
yes.
I think
So-
that will be the, if we must place emphasis more on this locality and acceptable to the Anganwadi worker.
Yes.
When it says only Anganwadi worker, it obviously means Anganwadi worker of the village in
Area.
question.
And my your lordship may decide this particular matter on the basis of the material available on record. Next week, my lord, it can be taken.
Next week, Aji.
Next week, as so.
Or further arguments in part, with this matter. What karo? Sorted to karo, sir.
5th September.
Yeah, kaho? Habo?
5th September.
Kitna? Gote bata, 5th September.
Fifth, my lord.
5th September, Mr. Patnaik.
Yes. Item number 12. 12, my lord. May
Your lordship has called for a WBC, which is not correct. That is WBC number 2395 of 2020.
ভুল রয়ে গেল
সেই যে নম্বর
15586 টা ভুল হয়ে গেছে না
সেটা হচ্ছে 23,995
আচ্ছা হଉ সেটা কইଥିଲେ এই নম্বরটা কইଥିଲେ
না ମୁଁ କହିନଥିଲି ମୁଁ ସେଟା ପାଇଲିନି ହଠାତ୍ କୋର୍ଟ ତାଙ୍କୁ ସେ ଯୋଉ ଏ ରେଟ୍ ଟା ବି ଆମର ଏ ରେଟ୍ ଟା ସବସିକ୍ୱେଣ୍ଟଲି
alright সেটা থাও আটটা পকে দাও এখন list this matter on
20 September.
40 September on 20th September along with the WPC number
WBC number 23995 23,995
23,995
95
23995 of 2020
Item number 13.
permitted to withdraw
Item number 14.
My lord, in item 14, my lord, On the last occasion, sir. On the last occasion, because my lord, the Paravage comment which I had received under earlier, that was inadequate, my lord. So after discussing with them, my lord, now I have prepared the counter and I am filing it today, my lord.
State Council files counter in court after serving copy on the other side. Mr. Mishra, you are ready or?
No, some other day because
Mr. Mishra, learned counsel for the petitioner wants some time to respond. If necessary, by filing a rejoinder, place this matter on 28th September, rejoinder if any be filed in the meantime.
Item 15. My lord, only bail matter may be considered because it has been listed under the hearing.
Hearing मैंने say bail पे हमारा
My lord, twice your lordship had granted me a liberty of limited period and in time I had surrendered. Now, my lord, more than out of 20 years, more than 10 years I have remained in jail. Here, my lord, conviction recorded is under section 376 2N and 6 POCSO Act and as well as 366 of IP. And as many as 8 witnesses are examined. And what I beg to submit, my lord, there are no convincing materials to arrive at a conclusion in convicting the appellant for a period of 20 years. And minimum sentence, your lordship, under section 376 2N as well as POCSO is 10 years. And I have undergone 10 years already. And if your lordship will permit me one by one materials, what are the materials? I don't know.
The appellant has been convicted and sentenced to undergo RI. For 20 years and it is submitted that the appellant has spent more than 10 years.
More than 10 years.
In custody by now.
10 years again. 4, 6, 14.
4, 6, 14. 4, 6, 14, 10 वर्ष 2 मास ହେଇଗଲାଣି.
Paper book has been prepared?
No.
The paper book has not been prepared, for which the appeal has not been able to be taken up for hearing. Considering the fact that the chance of the appeal being heard in the immediate future is bleak, and the appellant has in the meantime spent more than 10 years in custody, I am inclined to take a lenient view by directing release of the appellant on interim bail for a period of 3 months.
3 months. Twice your lordship had granted.
Is it 3? That time हवा का था ना मैं दे दिली. That time हवा का था ना. 3 months.
My lord, can I pray that let it be hard?
Mo pakra boni. Criminal appeal is not within my. I am only hearing the bail matter. 3 months. अच्छी material अच्छी ना मैं final regular bail कर दी थी. मुझे खुद लिखना है.
Kidnapping अच्छी thereafter it has been corroborated.
My lord,
4 months कर दूँ. 4
Can it
months.
be had on any other day on merit? Your lordship will either it may be allowed or it may be rejected so that
Bail application.
Bail ta finally bail ta sun.
Final regular bail they have only because conviction hichi, victim kohichi, and there are materials, there is evidence. So the appeal, if the appeal is dismissed, then you will be have to stay for full 20 years. So since you have completed 10 years, I am granting you bail. Na conclusion. 4 months. I think it's reasonable. Or otherwise we'll take it up on some other day.
4 months, 6 months kon din.
4 months koil pera?
4 years.
Item number 16.
28/5/2021 and the presentation was a release on interim and surrender in time back, my lord.
You were granted liberty to move after examination of Rekhalata Behera and
Yes.
Manorama Behera.
My lord.
They have been examined PW 1 and 2.
1 and 2.
सर ଦେଖାଲା ବେରା ମନୋରମା ବେରା ସେମାନେ ଏକ୍ସାମ୍ ନେ ହେଇଚଲାଣି କପି ଆପ୍ଲାଏ କରି ସାର୍ ମିଳିଛି
अच्छा अच्छा
Already
copy
fine.
ଅଛି.
Already fine.
PW1 is Rekhalata Behra.
And PW2 is Monorama. Categorically stated, ये कोउतरे पहले किसी से specific करना है. 13 to 14 number of
Clearly position थे अपन का
ये कोउतरे assault कर दिया कहीं कोई ना. 13 to 14 number of ये कुछ person ये ले assault ये कर ले. Due to what previous inventory, due to assault of information, one of the.
Apart from that, they have also received injury, grievous injury that mother of the deceased and one dying declaration is also there of the deceased before the.
ପ୍ରାଣବନ୍ଧୁ ମଧ୍ୟ ଆମ ସାଇଡରୁ ଜଣେ ମରିଛି.
No.
ରହୁନହେଲେ ଆଉ କିଛି ଦିନ.
No. I rejected. No. Reject हो पछा आसो.
ନାଇଁ ନାଇଁ ଛୁଟି କରୁ ଆଉ ଟିକେ ରହୁ.
List when moved.
इंटरव्यू जाके धमक धमक करते साखी
छाड़ बिल तो नहीं पड़ता ना आपको.
इंटरव्यू ऑर्डर
आपण cancellation file करले नहीं. Cancellation file कर सकते. List when moved. Yes.
At note 17.
None appears. This is matter list when moved.
At note 18.
Please, your lordship. Hear me, lords. A murder took place. Then, on suspicion, these present two petitioners were arrested. And two others were taken to custody. So, 2 days after, because the deceased was supposed to marry a girl, the girl commits suicide. Now, the affair, issue 1, is lodged against 2 other persons that they, after the incident of that murder, they came to my house, knocked the back door, entered my house, threatened and told that we have killed her. Because of that reason, my daughter committed suicide. That is the case. That is how this case stated. 306. Now, my lords, police found that those 2 persons were in custody before the police, though they were not charge sheeted in the murder case. As suspects, they were there in the night. The CDR of both the persons were in different places. They found nothing. We are granted bail. They carried to Supreme Court. Supreme Court confirmed this honorable court's order in that murder case. When they found nothing, the SDPO in a supervising note stated that these are the persons, because they committed the murder, she committed suicide, so we have made him accused. Now the other 2 persons who have been named went and threatened, your lordship granted them anticipatory bail. Now we have been made accused.
Same order.
In respect of Anganwadi murder and
Anganwadi
complainant Sukanti Puhan, my lordship, see page 29, my learned brother has annexed. And these 2 persons are the person who abetted to.
No, have you seen my previous order?
Yes, madam. I have seen, madam.
So there in paragraph 4.
Given a U-turn. What's your order?
169.
So the same order can be passed?
Yes, madam.
All right, same order.
Charge sheet has been filed.
Same order.
Poisoning, but no external injury. Nil.
I don't know 19.
19 में please also. Then the similarly situated persons, those who are named in the affair under Annexure 1, this order has been passed.
Gaurang Sethi?
It has been rejected. Gaurang Sethi.
Rejected.
Gaurang Sethi has not been rejected. Granting liberty to petitioner to sign the forward, which shall be considered on its own merit. Same order. Same order.
Parity only.
Same order further, the court below shall apply the principle of parity.
In that order, I should mention that 161 CRPC, he has implicated the present petitioner But in another statement recorded by the IO, he has given a different version by implicating two others. We are the two others. Or say order a data change.
এইটা কাটাতে পারতেন আপনি সেই লাইনটা প্রিভিয়াসলি
Para 4.
Yes, item 20.
I don't know 20.
May I please your lordship, my lord, non-billable offence for 93,307 and 506 34 of IBC, my lord. My lord, I am see the injury report, no external injury, my lord. And say, injury.
আচ্ছা
What is the relation with the?
yes নিজ বেল মুভ করতেন
No, no. Another accused person, another person.
no I am sir
Petitioner is also Jan Maji.
Inhona Joyant Kumar Maji, accused na Joyant Maji.
কিছু অসুবিধা নেই তো?
Moon
My
to
lord,
me.
This present petitioner not been named in the affair. And what is the relation with
That's
the
a good
complainant?
point.
These are high case all right same order
File, my lord.
same order
Item 21.
May I please your lordship? Honorable,
Yeah,
honorable
no
court's order,
গণেশ পূজা
the similar
303,
order has been passed to me.
First, second, or same day was passed in respect of the court.
somebody else has been
Parity.
all right এদের খালি অ্যাড করে দেবে further the courts below shall maintain the principle of parity
Obiraj.
তাই না ইংলিশটা ঠিক খালি করে দেবো করে দিই yes oh supplementary list is over
Yes, ma'am.
କେତେଟା ଅଛି କି ପାସ ଖାଲି করে দিও
Pass over item number 10.
May I please, madam? Your lordship wanted me to file the certificates. I'm filing it to the lordship. Kind for
what certificate
say caste jogu jo schedule caste jogu exempted. সেটা accept ହେଇଥିଲା କିନ୍ତୁ certificate ନଥିଲା ବୋଲି ମୁଁ measure of the ଇଏଙ୍କର ମୁଁ ଫାଇଲ
you file your certificate we'll take it up on some other day
ଏଟା କେସଟା ଆସିଛି ଦେଇଯିବ ଆଜି ପରିଶ୍ରମ କରି ଆସିଛି
ପରିଶ୍ରମ ସମସ୍ତେ କିଏ ଏଇଠି ଗୋଟେ ପରିଶ୍ରମ ନ କରୁଛି ମତେ କହିଲେ ଆପଣଙ୍କ ଛଡା ଆଉ ବାକି
ନାଇଁ ସମସ୍ତେ ଏଠି ଆମେ ଏପଟେ ସେପଟେ your lordship
ପରିଶ୍ରମ କରୁନାହାନ୍ତି।
privileges ଆମେ ପରିଶ୍ରମ କରୁଛନ୍ତି କିନ୍ତୁ ଆମର ଟିକେ ଆମର ସେ ପ୍ରିଭିଲେଜ ନାହିଁ ଆମକୁ ଆସିବାକୁ ଶନିବାର ଆମେ ଟିକେ I can't be deprived of this. My senior is your lordship's honorable court's decision. That is not mine fault.
ଆପଣ you file your certificate in the
ମୁଁ memo କରିଛି with your lordship file କରି ଟିକେ place କରିଦେବି ଏଇଟା ନହେଲେ virtual କଲେ your lordship normally
this is for admission
fresh admission injunction ଟା ଅଛି ତ ସେଇଥିପାଇଁ ଟିକେ କରିଛି harass କରୁଛନ୍ତି
the counsel for the appellant files copies of the caste certificates of appellant number 6, 8, 9, 10, 11, 12 and 13 in court. What about the others?
ସମସ୍ତେ ଏକା ଗୋଟିଏ କାଷ୍ଟ ଗୋଟିଏ ବଂଶଧର ସେମାନେ ସବଷ୍ଟିଚ୍ୟୁଟ ହେଇଛନ୍ତି ଅରିଜିନାଲ ପ୍ରିଣ୍ଟିଂର all are same.
All right, the defect be ignored. Court fee is exempted or something like that. Yes.
May I please your lordship? But this is plaintiff is the appellant against reversing judgment, your lordship. But the suit was filed applying for declaration of exclusive right title interest and to remove the noting in the remark column in favor of the defendants to the effect that they are Sikkim tenants, which was decided in a settlement proceeding, your lordship. Now, my lord, the London trial court, your lordship will kindly turn to the judgment of the London trial court. That is, I have not made running page, I am sorry.
No, it's all right, I've got it.
Your lordship will see the findings on issue number 456.
Yes.
More particularly, your lordship may turn to internal page. Page 15. Page 15, your lordship.
Yes.
The court takes note of that the settlement authority has no power to create a right with the adjudication of a Sikkim tenancy. It's creation of a right. He can make notings of a decree or death of a person, the heir's name and all those things. But he decides and adjudicate, makes a noting of right of Sikkim tenancy, which the Land Trial Court considers is not correct. And another point that was raised was that the settlement territory is challenged beyond 3 years. Since declaration of right title interest was sought for, the court held that the court has got power to adjudicate, and accordingly it was decreed. After the decree was passed, it was carried in appeal. Your lordship will kindly see the appellate court judgment. The appellate court was to decide in the context of the settlement authority's power, because whether they could have made a noting with regard to Sikkim tenancy, but the civil court is not to also declare the civil tenancy, it is only the OLR authority. Appellate court proceeds to decide this right, whether they have Sikkim tenancy or not, and holds that yes, therefore the trial court is not correct, and accordingly allows the appeal. My substantial question of law, your lordship will kindly see only one question I have formulated at page 13 of the second appeal. Two questions I have formulated, which I was submitting, that whether the settlement officer can do it and whether in the absence of adjudication by competent authority it can be done.
I think that one will do.
Two is also intermingled, my lord, because Sikkim tenancy decide any koti.
All right. Heard Sri S.K. Mishra, learned senior counsel with Sri Biswajit Patnaik, learned counsel with the appellant. Peruse the impugn judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 13 to 12. Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within. No, I think there's some state parties are there. Issue notice to respondent number 1 and 2. You state,
I'll give copies.
state you can appear. Yes, Mr. Das.
Huh?
State you can appear in this appeal. From 3 in the state of Odisha, collector, Tahsildar, Tahsildar, revenue officer, settlement officer. You can appear.
Under the CPC in suits, state is represented through collector.
Collector in number pakkha state of Odisha.
Issue notice to the respondent numbers 1 and 2 by registered post to so returnable within 4 weeks. Requisites within 3 working days. The state council accepts notice on behalf of respondent numbers 3 to 7.
Let him serve one copy and let notice go. That would be better.
Notice will go?
Yes, that would be better because
Once your lordship is issuing notice in this court, state can accept. Once notice is issued, before notice copy never need. After notice to copy nahi paribe na.
Let adequate number of copies be served upon the state council. Stop. Call for the LCR. List this matter. November. On 24th November. Aye.
I hear a decree of permanent injunction was granted holding that I am in possession.
Status quo with regard to the suit property be maintained till the next date.
I am grateful, my lord.
Yes.
So item number 23.
A scheduled property I have given. Obliged.
Yes. So this has not been admitted.
My lord, in fact, the LCR was called for at the initial stage, and there is a stay of execution. The defendants are appellants before your lordships against the confirming judgment. Plaintiffs are the respondents number 1 and 2. Now, in the meantime, one of the respondents is expired. Plaintiff number 1 is expired. Plaintiff number 2 is there. So, my lord, on that day, a question was posed whether the whole appeal will abate or not. My response submission would be that the whole appeal will not abate, because there is already an order that the appeal as against the respondent number 1 has already abated. So, because there are two plaintiffs. Plaintiffs claim that their source is X and they derive the property through X. Defendants also claim that they have derived the property through X, but claiming that two separate persons. They said the the common ancestor was Jasmi. Plaintiff said that Jasmi married Khela, but Khela had one son, and these plaintiffs are the sons of Suna. But the defendant's claim is that Jasmi married one Signaria, and through them they got the property. The dispute arose in the settlement because the names of the defendants as well as the plaintiffs were recorded in jointly.
No, but now shall we hear it finally?
Well,
Yeah,
my
that's
national
it,
submission is that confirming judgment, it has to be decided whether Jasmi was the wife of Khela or Jasmi was the wife of.
No, it's a confirming judgment. It's a factual finding.
Factual finding.
So why should it be? Why should this court interfere? Tell me.
That is exactly what I am saying. Because there are the statements with
If the
regard
finding is not perverse, will this court enter into that controversy again, factual controversy?
that is your lordship's judge. But in that respect, my lord, I will simply submit one thing that the plaint statement, the pleadings in the plaint and the pleadings made by the plaintiffs in the plaint and the evidence given are totally different. Once they say that Khela predeceased Jasmi.
It must have been dealt with by both the courts below.
Those contradictory statements have been ignored by both the courts below.
Yes, what were you saying?
Your Lordship, my humble submission will be that the appeal will abet as a whole on the abatement of one.
But the decree cannot be severed.
Your Lordship,
Probably.
it is an indivisible decree.
My response submission would be that the whole suit will not abate, because both the plaintiffs, they claim from one source.
All right, we'll examine it on the next date.
Yes, ma'am.
9th September. We commencing 9th September. Yes.
So right now 33.
Please, my lord, I'm appearing online in this matter, your lordship. I'm for the appellants.
Appellant.
She's there. I'm the counsel on records will be submitting.
Yes.
Leave me, I make my submission. Your lordship, in this matter, I'm challenging a judgment passed by the district court. This
This is for admission.
That's correct.
She's from.
This is for admission.
For fresh admission.
Okay.
For fresh admission, your lordship. This dispute arises out of a partition matter. My lord, in this partition suit was decreed, and in that, two defendants were challenging the allotment of properties. They had never challenged the preliminary decree. For the first time, they challenged the final decree in appeal. They were appearing in the lower court, and their only objection is that they have been given land parcels which are not convenient or favorable to them, and they are relying upon the valuation. Your lordship, it is my respectful submission that if preliminary decree is never challenged, there is nothing to be challenged in the final decree, and this is squarely covered under.
I'm sorry, I couldn't hear you. You said that preliminary decree cannot be challenged.
Preliminary decree can be challenged. If it is not challenged, final decree cannot be challenged.
That is the law.
Precisely.
That is the law. That is the statute.
Quite right.
The preliminary decree has not been challenged. The final decree cannot be challenged.
Quite right, your lordship.
Here, what has happened?
It has not been challenged. The preliminary decree, my lords, I have annexed to my appeal memo, my lords. Preliminary decree was never challenged by the defendants, my lords.
Okay.
I am appearing for the plaintiffs and the appellants.
Obviously.
Preliminary decree was not challenged. Final decree proceedings instituted. Commissioner report was prepared on the spot, my lords. In their presence, they had appeared before in the final decree proceedings before the court below, my lords.
Where is that provision?
Provision is, my lords, order 8.
Your lordship will first see
Yes.
section 97, my lord.
Section 97.
96.
Section 97, we are on the CPC, we are on the point of appeal from final decree.
He shall be precluded.
Where no appeal from preliminary decree. Where any party aggrieved by a preliminary decree passed after the commencement of the code does not appeal from such decree, he shall be precluded from disputing its correctness in the appeal, which may be preferred from the final decree. Your lordship, my submission is that final decree as such does not constitute any decision on the merits of the matter. Preliminary decree determines the rights of the parties, and final decree is only a ministerial act of executing that. So therefore, there cannot as such be a challenge to any final decree.
All right, all right, all right.
And we also see the provision of Order 20, Rule 18, which is the cases in which a preliminary decree may be passed, which covers partition.
Partition is the main.
Quite right.
Yes, heard, yes, Mr. Das, I would like to.
My lords, her name is Miss Lokhandwala,
Rehmat
along with
Lokhandwala.
What, yes,
Rehmat, it is spelled as REHMAT. I have put it in my appearance here also.
heard Miss R. Lokhandwala, Learned Counsel for the appellant, to use the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Good, ito kar do.
Page number 35. We have given
I think one
several-
will do.
Well,
We'll simply say one will do. One will do, isn't it? Substantial question of law. The following substantial question of law, 35, huh? 35, page 35, one tab kar diyo. Whether the judgment of the learned district court, this is not happily worded. Whether the first appellate court, whether the first appellate court erred in law in interfering with the final decree of partition, even though no appeal had been preferred against the preliminary decree passed in the suit. Yeah. Issue notice to the respondents by a registered post with AD returnable within 4 weeks. Requisites be filed within 3 working days. Will the LCR be necessary?
my lords,
Will the LCR be necessary, Mr. Das?
here my lords may call for or
Let us call for. Also call for the LCR. Let this matter. Huh? In the week commencing 25th November. What IA?
IA, my lords, for stay of operation of the judgment, my lords, of the learned appellate court, because the appellate court has again remanded back the matter, directing the trial court to again press for a commissioner report.
Operation of the impugned judgment dated 22/6/2024 passed by the learned third additional district judge Balesur in RFA number so and so shall remain stayed till the next date. Yes.
Most grateful, Your Worship, most grateful.
Yes.
So item number 45.
Hearing. Let this matter.
We commencing 9 September.
In the week commencing 9 September. Well,
So item number 46.
9 September, hello. 46, yes. Okay.
My senior has some personal difficulties.
We commencing
17 September.
17 September.
Same to you also.